Hi, and welcome back to Military Law Talks. So, jailed for speech. Could someone actually be sent to jail because of something they said here in America? Actually, yes, particularly in the military, because while we do have First Amendment rights, those can be somewhat limited, particularly for military officers because of our unique military mission and the chain of command. So, today I'm going to tell you a case that's kind of old, but I think it's super interesting and it'll set the stage for my video that I'm going to do tomorrow on crisis of command about Stuart Scheller, who wrote that book and who's going to join the Trump administration. So let's think back. So we're going to go back in time to 1965. So what was going on in 1965 in the military? Well, we're in Vietnam War. So during the Vietnam War, right, we had a huge ramp up and we had a draft. And so, our generation, we don't know a draft because we've had enough volunteer army to fill up our ranks and enough volunteers to fill up our ranks. We haven't had to have a draft. But in the 1960s, there was a draft. And so Howard Levy, so he was drafted, but there was a program that you could actually defer the draft for doctors. So you could defer the draft while you go to medical school, and then you could come and residency, and then you could come serve in the military. Fun fact, Anthony Fauci actually entered the military under this draft deferral program for doctors. So that's a fun little aside. So Howard Levy, so he was a physician and he went through this program. So he was in the U.S. Army and he was stationed at Fort Jackson, South Carolina. So their troops are being trained, basic training, lots of junior soldiers around. And part of his job, so he was the chief of dermatology, and part of his job was that he was supposed to train special forces medics in some basic combat care to help them before they would go to Vietnam. Now, Howard Levy was against the war, not really the best person to serve in the military, someone who's against the war. And so he refused to do this training. So he just never did it. He's a doctor in the army, and that's part of his duties, and he just refused to do his duties. So the hospital commander later found out that he refused to do this, and so he gave him a direct order, a written order that said that he needed to do this training. But he also made a whole bunch of statements too. So he was really anti-war, and he made a lot of very public statements. So he made these statements in front of enlisted soldiers, right? So he's an officer, he's a captain in the U.S. Army, and he's making these anti-war statements to soldiers. So he encouraged soldiers not to go to Vietnam, particularly African American soldiers. He called special forces soldiers liars, thieves, and killers of peasants and murderers of women and children. So it was pretty inflammatory speech, and he actively was discouraging enlisted soldiers to not go to Vietnam, to refuse to go to Vietnam. So, like I said, Levy was given this direct order to do the training. He refused to do so. And he was also making these very public statements to junior enlisted soldiers. So he eventually was court-martialed. So he was charged with violation of a lawful order, an Article 90 violation, and then conduct which is prejudicial to good order and discipline. That's an Article 134 offense for his statements, for his speech about Special Forces personnel, and conduct unbecoming, an Article 133, that's conduct unbecoming an officer, for his statements encouraging enlisted soldiers not to go to Vietnam. So the bulk of his charges were based on his speech. So he was ultimately convicted at court-martial. Let me show you. I got a picture of it. Let's add this. So this is a real picture. So this is Levy in in the middle, in the handcuffs, in his uniform. So after he was convicted at court martial. So he was convicted at court martial, and then he was sentenced. He did get a jail sentence. And so while he was serving, well, after he was convicted, he appealed his conviction. And in the military, you get an automatic first appeal. It's automatic if you have a qualifying sentence. He had a qualifying sentence. It was automatic, and his conviction was upheld on appeal. So then he filed a writ of habeas corpus. Now that's a little Latin. That the literal translation is "you have the body." It's essentially a petition to a court to say, "Hey, I'm wrongly detained." And it's actually a very, very old right. This writ of habeas corpus goes back hundreds and hundreds of years. And so he filed this writ in federal district court. So remember, he's in military courts. He was court-martialed in military courts. And so he filed this writ of habeas corpus in federal district court. And the district court denied his writ. So, and then he appealed that. The appellate court reversed the ruling and decided that Articles 133 and 134 were void for vagueness, and they were unconstitutional because they're not real clear on like what's a crime and what's not. That was his argument, and saying, hey, he couldn't have known that his speech would subject him to jail time. And so then the Army appealed to the Supreme Court because these Article 133 and 134 are very integral to the military justice system. They're very common articles. They've been used for a really long time, and they wanted to get the Supreme Court to weigh in to say that they're not unconstitutional. And so the Supreme Court had to decide, was his court-martial conviction constitutional? And related to that, did he have a First Amendment right to make these statements? Or could these statements be criminalized? Could he go to jail for the statements that he made? Well, the Supreme Court discussed that the military has a long tradition of having a separate military justice system, that the military is really a separate society with its own laws and traditions. And I mean, think about it. Everyone who's been in the military or been around the military, we even speak differently, right? We have like military speak. Even the different service branches kind of have different terms for different things, right? So we definitely have a different society. And they said that the cornerstone of this society is obedience. And this is a quote from the case, the military constitutes a specialized community governed by a separate discipline from that of a civilian. The rights of men in the armed forces must perforce be conditioned to meet certain overriding demands of discipline and duty. Essentially, they're saying, hey, officers and particularly commanders need to have good order and discipline. And because of that, they have to be able to regulate those within their command. And particularly officers like Levy, right? He's a captain in the Army. They hold this special position of responsibility in the armed forces. And so because particularly he made these statements to enlisted soldiers, that was particularly aggravating, right? If these statements were made in just a private conversation, probably wouldn't have been charged. But the fact that he's during war making these statements, encouraging junior enlisted soldiers not to go to Vietnam, that thus harming the war effort, that's when the courts ultimately in the command, right, stepped in and said, hey, you can't talk like this. And the courts agreed. So the Supreme Court agreed that, yeah, the military system is different. And military law has long been accepted as a separate body of law from civilian law, and it's been long recognized by the Supreme Court. They said that the UCMJ is different than other criminal codes, right? We have military specific crimes under the UCMJ because there's just a different need for the military. There's a broader range of criminal conduct because of the unique mission and of the military and the need for discipline within the ranks. And so the court determined that yes, military members do have First Amendment rights. However, they can be limited. And in this particular situation, Levy's speech was very harmful to the unique mission and requirements of the military. It would harm the obedience to the chain of command, and it would harm good order and discipline. So Levy's speech could be limited in this manner. And the courts found that these articles, 134, 133, were not void for vagueness. Actually, the courts pointed out that these articles, this good order and discipline, service discrediting language, had actually been a part of the military justice system for hundreds of years, going back to Revolutionary War times. And actually, these two articles were based on similar articles with similar language from the British Royal Navy and the British military. And so there's a long tradition in military law that you have these kind of, we call them general articles, that this kind of misconduct that is service discrediting or prejudicial to good order and discipline can be subject to criminal discipline. And so at the end of the day, yes, military is a separate society and it has a separate and unique military justice system. And the Supreme Court has long recognized that that's totally valid and they totally respect the military's ability to discipline their own. And the Supreme Court made it clear that yes, while service members do have First Amendment rights, they can be limited because of the unique circumstances of the military. And so that's a case from 1975 that discussed that essentially a military officer was jailed, was convicted at a court-martial for his speech. And like I said, in the next video, I'm going to talk about crisis of command, a recent case where a military officer was also jailed for his speech. And so join me for that video tomorrow. Thank you. Thank you for joining me. And if you got any value out of the content, please like, share, and subscribe. I'm a new channel, so please help spread the word. I really appreciate your sharing this message out there. If you have any comments or questions or requests for additional content, please put them in the comments below. Thank you.